Today we're exploring the legal complexities behind one of the most unique and controversial cases in recent years. Wu-Tang Clan's rare album Once Upon a Time in Shaolin, Martin Shkreli, and the US government. This case touches on issues of ownership, intellectual property, and how the legal system responds to high-value assets caught up in criminal activity. On the surface, it may seem like just another story involving a high-profile criminal case, but the legal implications here run much deeper. This isn't just about who owns a rare album, it's about the tension between the rights of private individuals and the broader cultural impact of restricting access to something that could be considered a public good. In 2015, Martin Shkreli bought the only copy of this album for $2 million. Not long after Shkreli was convicted of securities fraud and the government seized his assets, including this album. Now, here's the interesting part. The sale contract prevents anyone from commercially releasing the album until the year 2103. So we have a situation where a piece of art is legally locked away for nearly a century. This raises important legal questions about the balance of power in contract law. Are contracts like these reasonable, or do they unfairly deprive the public of access to important cultural works? Let's talk about ownership and rights. On one hand, Wu-Tang Clan has the right to control how their work is distributed, and Shkreli lawfully purchased the album. But should contracts like these that restrict public access for decades be allowed to stand? As a lawyer, I see the importance of protecting intellectual property, but there's also a strong argument that cultural work shouldn't be locked away for the benefit of a few. This brings up questions about the role of contract law in regulating access to significant cultural pieces and whether current laws truly reflect the public's interest. Now, here's where things get even more complicated. Shkreli recently claimed that he may have lost the album. Legally, this opens up a number of issues. Pleaser DAO could potentially sue for breach of contract if Shkreli can't deliver the album. But beyond that, if Shkreli genuinely can't find it, it raises the question of whether the title of the album can even be transferred. Can you legally sell something you don't have in your possession? This situation could easily lead to further legal battles, and it's a perfect example of how poorly managed assets can create long-term legal problems. So what's the likely outcome here? We could see legal action from Pleaser DAO against Shkreli if the album isn't found. But beyond this specific case, the real issue is how the law balances private ownership with public interest. This case highlights the tension between protecting the rights of creators and owners and ensuring that cultural works like this album aren't kept from the public for generations. The legal precedent set by this case could have broader implications for other high-value collectibles and intellectual property cases moving forward, making it even more significant in legal circles. At the end of the day, this case is a reminder of how wealth and power can impact the accessibility of cultural works. Legally, the system seeks to be working as intended, but should it? I'd love to hear your thoughts. Drop a comment below. If you're interested in more legal analysis of fascinating cases like this one, hit the subscribe button and stay informed. And as always, remember, Mac has got your back.